Mr. Jenkins, sorry we're boring you, but if I hear you yawn out loud again, it's not going to be good. Sit up, pay attention, wake up. This is all about you today. Okay, so in each of these motions, they were second amended motions to revoke unadjudicated probation. Mr. Jenkins pled true in each of those to counts 1, 2, 3, 4, 9, 10, 12, 13, 14, and 18 on probation for theft of a firearm in each case, which are state jail felonies. Is everyone ready to proceed?
We are, Your Honor. I'd like to put on the record what the offer is, just for him to reject the offer,
Sure.
if I may.
Yes.
Your Honor, it's my understanding that the offer is 20 months on the motion to revoke probation and 10 years on the ag robbery case with a dismissal in the fraud case. And Mr. Jenkins has indicated that he wants to reject that offer. I've indicated to him that the state is likely going to file a motion to stack those sentences in all 3 cases, and he's expressed to me that he wants to reject that.
Mr. Jenkins, so I want to make sure you understand, you've talked to Mr. Parker about all of that, is that correct? And we'll get through today these 2 MTRPs, and then whatever happens on those after that, that aggravated robbery and the fraudulent use or possession of identifying information. I already did it. Those will be set for trial. If you go to trial and a jury finds you guilty, then the state can request that I stack whatever punishment you get then on top of what you get today. Do you understand? And you want to reject that and go forward with this hearing, and then we'll figure out a trial date for other cases. Is that what you want to do? I'm sorry?
Yes.
Okay. And so, Mr. Parker, I will allow you to go forward with argument on punishment.
Your Honor, I mean, this is on motions to revoke probation. And I mean, the only thing I have to offer is that my client is set in jail. And obviously, I'm not going to argue as to the facts of the other alleged crimes. Just his probation here is that drugs has been a problem for him, which his probation officer has admitted to. And my client is set in jail for a considerable amount of time, which he's expressed to me, he's expressed to his probation officer. He's realized, I mean, he's been there for several months, and he's learned that the people that he hangs around aren't the right people for him. He wants to do better in life, be there for his family, and I think some type of treatment and to allow him to continue on probation is the best thing. Otherwise, I would just defer to the court their decision.
Thank you, Mr. Parker. Mr.
Judge,
Smith?
Based on his activity in the jail, based on his activity when he's not in jail, all of the allegations that were found true, all of the new crimes that have been committed, continuing him on probation after having successfully completed both tracks of ISF, would just not be appropriate. We ask that you find him guilty, revoke his probation, and sentence him to 24 months in the state jail in each case.
Thank you, Mr. Smith. So, Mr. Jenkins, one of the things that Mr. Parker said, and that a lot of especially younger offenders come in here to say, is that they're hanging around the wrong people, and that's part of the problem. And what I typically see, and more, is that what I think you are as well, is you are the wrong person, right? I mean, nobody's forcing you to do anything, and everybody wants to do this and say that somebody else is at fault for being a complete menace in our community, running around with guns, stealing from people, being part of a group that ends up shooting someone, that terrorizes a family in the middle of the night. You didn't have to be there, so you are the bad person. My only regret here truly is that I only have 2 years to give you, and that's not going to keep you off our streets long enough. It's ridiculous that you were given the opportunities that you were given when you got this probation. And I know what I said to you because I say it to everyone, especially you young ones. I'm sending you to ISF so that you can learn how to get out and be successful on probation. And you got out and you just running around with stealing and guns and shooting and all the bad things like you're living in the Wild West. In cause number 22-39541, I'm going to find, again, that you entered your pleas of true to counts 1, 2, 3, 4, 9, 10, 12, 13, 14, and 18 freely and voluntarily. In addition, in cause number 22-39210, find that you entered those same pleas of true freely and voluntarily. In each of those cases, also make the findings that counts 5, 6, 7, 11, 15, 16, 19, and 20 are true. Find sufficient evidence at this time to find you guilty, and in cause number 22-39541, find you guilty of theft of a firearm. Sentence you to a term of 24 months in the state jail prison. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 22-39210. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you to a term of 24 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Give me just a second. I need a certification. Thanks. I'm going to hand you in just a minute. You'll need to sign it, and then I'll give you a copy of a document called your Certification of Right to Appeal. You do have some rights to appeal this decision and these findings today. You can talk to Mr. Parker about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can also talk to Mr. Parker. What we'll do now is move those to the ag robbery and the new fraudulent use or possession of identifying information. We'll put it on one announcement docket. If it's not worked out at that point, then we'll get those set for trial as quickly as possible.
So the hearing begins with the judge noticing that Mr. Jenkins looks bored and even yawns loudly in the courtroom, and that immediately irritates the judge. He stops the proceedings for a moment and tells Jenkins that if he hears him yawn like that again, it won't be good for him. He tells him to sit up, pay attention, and wake up because the entire hearing is about his future. He had originally been placed on probation for theft of a firearm in 2 separate cases, both of which are state jail felonies. The court explains that there were multiple violations, and Jenkins had already admitted to several of those violations before the judge makes a final decision. The defense attorney explains the plea offer that had been made by the state. The offer was that Jenkins would receive about 20 months for the probation violations and 10 years for an. The attorney also tells the court that he warned Jenkins about, especially because the state could later ask the judge to stack the sentences, meaning he could end up serving much more time. He tells the judge that drugs have been a major problem in Jenkins' life and that after spending several months in jail, he has started to realize that the people he was around were a bad influence. According to the defense, Jenkins now wants to change his life, get treatment, and be there for his family, instead of sending him back to jail, but the prosecutor strongly disagrees. He tells the judge that Jenkins has continued committing crimes and that his behavior both inside and outside of jail shows he is not taking probation seriously. The prosecutor argues that after everything that has happened, continuing probation would not be appropriate, and he asks the judge to revoke it and sentence Jenkins to 24 months in state jail for each case. Then the judge speaks directly to Jenkins. He says that he often hears young offenders claim they were just hanging around the wrong people, but in many cases they themselves are the wrong influence. guns, steal from people, or be involved in violent situations, and that those were his own choices. The judge describes his actions as dangerous to the community and says he had already been given opportunities to change, including special programs meant to help him succeed on probation, but instead he went back to crime. The judge even says that his biggest regret is that he only has the power to give him 2 years. He says it is frustrating to see someone get multiple chances and still continue down the same path. After that, the judge gives his final decision, finds him guilty, and sentences him to 24 months in state jail for each case. He also gives him credit for any time he has already spent in custody. The judge then explains his right to appeal and warns him that under Texas law, he is no longer allowed to possess a firearm or ammunition. Robbery and fraud cases will be scheduled for trial later, meaning Jenkins could still face more serious consequences depending on those outcomes. So in the end, his probation was revoked and he was sent to state jail while his more serious charges are still waiting for trial. If you want more real courtroom stories explained in a clear and simple way, make sure to subscribe for more.